Ano na ba? Ano na ba ako? Ano na ba tayo guys? Diba napaka-exciting nung pinag-live stream natin. Nag-live stream tayo ng aral. Sobrang exciting. Hindi ko naisip mag-live stream nung addict ako sa ML. Ngayon nagla-live stream ako mag-aral guys. Sana nakita nyo gano'ng kagaling mag-1-1 na laging savage. Pero hindi eh. Nakikita nyo kung gano'ng kabulok magsagot ng question sa bar. Pero Gina, check natin. Live na ba ako? Okay. And we're live. Game. Tapos dito, live na ba tayo? Live na ba tayo mga kababayan? Okay. Live na, live. So, set up tayo ng stuffs natin. Una DND. Okay, game. So, set up tayo ng Pomodoro tayo. Pomodoro natin is 1 hour. Okay. Okay. Game. Question number ano to? 16. Tapos ano to? 1-1, no? Sige, game. So, si Lebron, a Makati resident, obtained a 350,000 loan, bank secured by real estate mortgage for over his lot located in Quezon City, with an assessed value of 500,000 pesos. Lebron failed to pay despite written demands. The bank intends to file an action for judicial foreclosure of the real estate mortgage. Okay. Where should the action for judicial foreclosure of the REM be filed? And in which court? Naku, ano ba to? Civil procedure? Banta lang. Saan daw yung... Saan ipa-file? Saan venue? Sino may jurisdiction? Venue and jurisdiction yung tanong. Si Lebron ang nangutang. Real estate mortgage sa lot sa Quezon City. May 500,000 assessed value. Ano ba? Hindi ko alam. Kapag judicial action for judicial foreclosure of real estate mortgage should be filed, kung mangungula ako sa Quezon City yan, where the property is located, so magbubulatik tayo based on that. Pero tingnan natin yung sagot. Diba? RTC. Okay, judicial foreclosure proceeding is an actual quasi in rem. As such, jurisdiction of the person of petitioner is not required, it being sufficient that the trial court is vested with jurisdiction over the subject matter. Okay, so RTC has exclusive original jurisdiction in all civil actions which involve title to or possession of real property or interest therein where the assessed value exceeds 400,000 pesos. Okay, so kapag monetary value or action for sum of money, 2 million ang threshold. More than 2 million ang RTC. 2 million and below, MTC or first level courts. Sa ano naman, or ano ba to? Civil actions involving title, possession, or interest. So, isasabi ni Justice Hener na tip for determination of real actions, or in this case, a quasi in rem action should be 400,000. 400,000 and above, 401 pesos and above is RTC. 400,000 below, 400,000 pesos and below is first level court, MTC. Subject property is located in Quezon City. The assessed value is 500. So, above siya ng 400, action for judicial foreclosure of the REM should be filed in the RTC of Quezon City. Okay, sige. Game. G. Sagot. Here. Nasaan yung here? Praksado sa'yo. Ang galing ng here na yun, no? Dati ang dami pang, in this case, at the case at hand, in the case at bar, here lang naman palang kailangan natin, guys. Sarap ng kape sa Lawson. Nescafe white ba yun? Nescafe white na shake. This is not sponsored, guys. Talaga. Okay, next. Asha Incorporated sued Kobe. Mga basketball player. Kanina, mga vlogger yung tanong sa atin. Kahapon pala. To serve summons, the chief. Teka lang. To serve summons, the sheriff waited in the lobby of Makati Hotel where Kobe stays whenever he's in Manila. The sheriff failed to serve the summons because Kobe left the hotel for an emergency. Umalis si Kobe. Pagkatapos, yung sheriff nagtanong kay Kobe, tapos hindi daw din-disclose ng hotel dahil confidentiality. The next day, nagtanong ulit. So the following day, sheriff left summons and copy of the complainant with the security officer of Manila Hotel. Okay. Even as the CSO refused because Kobe had already checked out by then. The sheriff thereafter filed his return, stating the dates, times, and places of his attempts, the name of the CSO, and the fact that the complainant was served with summons. When Kobe didn't file an answer, Asha moved to requirement 4. Valley substituted service of summons. Kobe is a resident of Bukidnon. And sa Makati Hotel siya nag-stay. Under the rules of court, it is within the residence of the defendant, not residents. Technically, residents niyo yung Manila. So, kailangan at least three separate attempts on two separate days. Tapos, iiwan na lang sa Chief Security Officer. Okay. Ang ganda naman ng tanong na to. So, the beauty of this question, guys, is the question of whether residence, gaano ba siya katagal? Is temporary residence in hotel counted as residence for purposes of this? Kasi tandaan natin na ang residence is kung saan ka currently nakatira. No? So, the technicality is residence niya yung Manila pag nandito siya. Pero hindi eh. Do you become a resident of a place when you stay in the hotel of that place? I differ. I beg to differ. So, hindi siguro. So, if that's the case, there was no valid substituted service of summons. No. There was no valid substituted service of summons. Under the rules, service must be done at the principal residence of the defendant here. The service was done in a hotel. This is cannot be counted as the principal residence of the defendant. Hence, service of summons in the substituted service of summons in the hotel is ineffectual. Okay. Question. Diba? 5 points. Nag-decide na naman ako. 5 points. Malaga, tumatama tayo dun sa concept, no? Medyo malapit naman tayo. Hindi naman malayo. Guys, malapit na. 36 out of 500 something. Kailangan natin bilisan. Bilisan natin, guys. Bilisan natin. 10 days after service of summons. Teka. Yung aking lap timer. Stopwatch. Start lap. Okay. 10 days after the service of summons. Defendant K filed a motion to dismiss the complaint for collection of sum of money against her on the ground of improper service of summons, on the basis of which the court did not acquire jurisdiction over her person. If you were the judge, Teka, when you submit to the court as a general rule and you file motions, you technically submit to the jurisdiction of the court. Yan ang general rule. So, pumunta siya sa court. The only exception is if you are questioning jurisdiction of the court. Okay. If you were the judge. Okay, so nagpunta ka sa judge, yun yung abogado mo. Okay, gets ko na. My answer. If I were the judge, I would order the counsel of Kai to serve. The summons. Under the rules, should the counsel how do I phrase this? Under the rules, the counsel of the defendant uh, shall be ordered by the court to issue summons in the case where affirmative affirmative relief is sought from the court for the dismissal of a complaint for the improper service of summons. Here, the issue raised by Kai is the improper service of summons. Hence, the counsel may be ordered by the court to serve summons to his client instead. Napakagaling tayo. Tawang-tawa ako dito, guys. Kasi parang sinabi mo, teka, judge, walang jurisdiction kayo, hindi nyo na-serve ng tama yung summons sa client ko. Sabi ni judge, oh, ito, serve mo sa kliyente mo. Napakatalino, di ba? Oh, tingin. Ano sagot dito? A motion to dismiss is generally prohibited except on the following grounds. Litis pendentia, res judicata, and no jurisdiction over subject matter of the claim. So, lang yan lang motion of dismiss. Dito, the ground relied upon is lack of jurisdiction of the person. Feeling ko medyo mas malapit nag-decide. Pala-decide ako yun. Ano ba yung sa civil procedure? Tingnan natin ha. Itong bago. Yung 2019. Ito. Napin natin yung summons. Ito. By whom served? Validity of substituted service. Service upon prisoners. Nasaan ba yun? Ito. Section 13. Basa. Ano sabi? Duty of counsel of record. Where the summons is improperly served and a lawyer makes a special appearance on behalf of the defendant to, among others, question the validity of the service of summons, the counsel shall be deputized by the court to serve summons on his client. O, di ba? Napakatalino ng mga gumawa ng ating batas. Hindi pala to. So, administrative matter. So, Supreme Court pala gumawa nito. O, di ba? Ating mga dear honorable justices of the Supreme Court. Galing. That's the wisdom of the law. O, sige. So, pero kakopy-paste natin yung sagot dito. Pero feeling ko, mas 5 points yung sagot ko. Bibihira yun guys. Bibihira yun. Bihira yung mas confident ako sa sagot na suggested answer dito. Pero, let's go. Yun nga, maganda dun sa bar exams, guys. May suggested answers, kahit UP Law Center yan. Pero there is no one correct answer. You can always argue. That's the beauty of it. So, as long as your argument holds water, yeah, then you should be able to push through. 36 out of 556. Lap. 5 minutes, 37. So, ang goal natin is less than 5 minutes. Let's go. Si Attorney Wu. Nandito si Attorney Wu. Korean novela naman yan. Okay. Newly hired lawyer of a law firm, Book Samurai Express. Duly accredited courier of the service within NCR. Serve a copy of a motion for reconsideration to Attorney Han, counsel whose office in the City of Manila. Attorney Han moved to deny the motion for failure to contain a written explanation as to why the motion was not served personally. Was the motion for reconsideration properly served? Okay. And B, what shall be considered as proof of service of this motion? Okay. Okay. Nasa City of Manila daw yung adverse party. Ang alam ko basta may leave of court. Sige. Must the motion for reconsideration serve? Yes. Kasi yung second na tanong parang it implies na tama eh. So sige, yes, it was served properly. Service may be done through courier under the amended rules. Letter B. Okay. What shall be considered under the rules? The proof of service to be considered shall be the confirmation. Ano ba to? Ano bang tawag doon sa ganun? Confirmation. Parang text confirmation usually makalir. Confirmation. Receipt confirmation na lang. Ano ba ganun? Confirmation provided by Samurai Express. Hula lang yan. Tingnan natin. Ang sagot. Di ba properly served? Ang galing natin manghula. Isa hulaan mo niya kasi sa second na tanong parang sabi, tama yan. Considering na tama yan, tama. Anong proof naman nun? So tama. There is no longer a need for a motion to contain a written explanation. The rules no longer deem priority to pleadings motions shall be served. Thus, the motion was properly served without even. Di ba? Service may be done through courier. Sige na. Proof shall be made by who brought the pleading or paper together with the courier's official receipt or document tracking number. Sapat na ba yung document tracking number or official receipt? Doon tayo mali. So, siguro mga 2.5, 3 points to. Ganun. Yep. Natuto tayo dyan. Shall be made by affidavit of service executed by the person who brought the pleading or paper to the service provider together with the courier's official receipt or document tracking number. Affidavit of service. Yun ang pinakamahalaga. Affidavit of service plus document tracking number or the official receipt. Okay. Tandaan mo yan, Carl. Pabalikan natin yan sa ating second pasada. That was 3 minutes 46 seconds. Next question. Pabibilisin natin dahil ang daming tanong. Daming problema sa part. But ito yung trabaho. Jewel filed against his wife, Jewel, a petition for the declaration of nullity of their marriage alleging as ground therefore Jewel's psychological incapacity under Article 36 of the Family Code. The court denied the petition for insufficiency of the evidence presented at the trial. Much later, Jewel again filed a petition against Jewel for the declaration of nullity of their marriage. This time, the basis of Jewel's petition was the absence of a marriage license at the time their marriage was celebrated. Upon Jewel's motion, the court dismissed the petition on the ground of res judicata by virtue of the judgment in the first suit. Okay? So, tanong, may res judicata ba dito? Jewel, nag-file sila ng nullity. Tapos dininay nila. Kasi kulang yung evidence presented at trial. Okay. Tapos ngayon, nag-refile sila. Nag-refile si Jewel against Jewel. Tapos ngayon, ang basis naman is absence of marriage license. So ngayon, res judicata pa to. Manghuhula lang ako. Yes. Res judicata applies. Under laws, res judicata is applicable when there is an identity of the parties and the subject of the case. Here, the same subject which pertains to the nullity of their marriage is presented by the same parties, Jimwell and Jewel. Hence, res judicata will apply. Okay. Natin. Okay. Former judgment. Tandaan natin ha. Res judicata. Former judgment is final. There must be a finality in the former judgment. Second, it is rendered by a court having jurisdiction. And the parties, it is a judgment on the order of the merits. And there is between the first and second actions, identity of the parties of subject matter and causes of action. Okay. So, in a rule, as ruled by the Supreme Court, that the petitions for declaration of non-marriage based on different grounds have the same cause of action. Okay. So, kapag nag-nullity of marriage na kayo, guys, as umulit kayo, wala na yun. Touch move na yung una. Yung unang case, kung paano na-decide yun, yun na yun. So, dapat if you file a declaration of nullity of marriage, then it should be something na pinag-isipan, pinaghandaan, kumpleto lahat ng basis, and hindi siya parang, may kulang pang grounds, final lang natin ulit, trial and error lang tayo. So, in this case, hindi pwede mo trial and error. Kasi, kung anong decision sa unang case, yun na yun. Pag sinabing, okay, mali yung grounds nyo, hindi denied ang nullity nyo, okay. So, hindi pwedeng ganun. Okay. Okay, sige. Pero, kailangan ko sa ulo to. The former judgment is final. It is rendered by a court having jurisdiction over the subject matter and the parties. It is a judgment or order on the merits. And there is identity of the subject and the parties. Identity of parties of subject matter and cause of action. Number one, it is the judgment is based on a final judgment. The former judgment is final. Number two, there must have been identity of the parties, the causes of action, and the subject. Number three, it is the judgment or an order on the merits. And number four, it is rendered by a court having jurisdiction over the subject matter and the parties. So, ano nga to? Ang naalala ko, JOPAI to eh. JOPAI means jurisdiction. Jurisdiction over subject matter and parties. Ano yung O? JOPAI. Parties. Tapos, ayoko na, tanggalin ko na yung JOPAI. Gawa kong bago. Ano ba pwede dito? Final. Rendered or jurisdiction. Final rendered. Merits. Hindi pala. Final, jurisdiction, merits, and identity. Final, resume, identity. FJMI. Anong pwede ko mabuo sa FJMI? JMI. Hingi tayo ng tulong kay ChatGPT. Create a mnemonic for, what's this? Create a mnemonic for the words jurisdiction, final, merits, identity. Just find my identity. Ang galing. Okay, guys. Just find my identity. Kailan merong res judicata? Tandaan nyo, may just find my entity. Jurisdiction. There must have been valid jurisdiction upon the subject and the parties. No? And just find F. So there must have been a final judgment. The former judgment is final. Number three, just find my merits. The judgment must be, or order was based on the merits. Okay, and then just find my identity. There's an identity between parties and the subject matter and the causes of action. Diba? Galing. Ang galing mo, ChatGPT. Diyan ka lang, ha? Hindi kita tatanggalin dyan. Diyan ka lang. Huwag kang aalis. Just find my identity. Okay, tandaan mo yan, Carl. Copy natin to. Lagay natin dito, pero, of course, lalagay natin yung just find my identity dyan para hindi natin makakalimutan. Saan na? Here. Okay. Kailangan maalala natin to. Just find my identity. Ang galing mo, ChatGPT. Hindi mo makakalimutan to. 7 minutes, 53 seconds. Okay, let's go. Next. Isol Incorporated supplies rotisserie chicken products to the grocery section of shopping malls. It conducts kitchen operations in a refurbished house located in Palanan. Okay. Rona, a resident of Palanan, filed an action against Isol Incorporated to enjoin the operations of its kitchen on the ground that it emits intolerable odors and violates laws on waste disposal. In the same action, Rona also seeks to have Isol okay. So, gusto ni Ronang ipa-revoke yung ano niya, permit niya. Kasi nasa residential daw siya. Okay. In the complaint Rona filed, Chilak was prayed for the issuance of writ of preliminary to stop the kitchen operations. Strongly opposed huge financial disaster that it will suffer if the writ were to be issued, especially in light of the possibility that the suit could continue to be pending for more than a year. May the WPI prayed for already be issued? Okay, yun ang tanong. So, yun ang sasagutin natin. Ano bang issue sa case na to? Bakit siya hindi pwedeng i-issue? Si Isol is a rotisserie of chicken products. Okay? Tapos, sa refurbished house daw sa Palanan. Residential neighborhood, yun. Si Isol, nababahuan siya dun sa kitchen. Nag-file siya ng case against Rona. Si Rona nag-file against Isol. So, dapat hindi yan sa residential neighborhood. And nag-fail naman daw sa sanitary inspection and other procedural and health requirements si Isol. So, pinapastop niya ngayon yung business ni Isol. Sabi ni Isol, hindi pwede. Hindi ko alam masagot. Inefficient pang hula ngayon. Kunin na muna natin yung sagot. Sige. Para mabilis tayo. Ano nangyari? Ba't naging ganun? Ano nangyari? Low. Ano nangyari? Remedial. Page na ako eh. 36. Dito na ako. Ito. Suggested answer, no. WPI may not be issued. The writ of preliminary injunction may not be issued. Okay. Bakit? No preliminary injunction should be granted without hearing and prior notice to the party sought to be enjoined, except it shall appear from the facts that great or irreparable injury would result to the applicant before the matter can be heard on notice. So there was no allegation by Rona that great or irreparable injury would result to her before the matter can be heard. So kailangan mag-prior notice muna. Sige, mababalikan natin yan. Next. Spectral. This prior determination of the status as a legal heir in a separate procedure of ordinary civil action, seeking the protection and enforcement of ownership rights of such legal heir vested by the law of succession. Ano daw? Protection. Okay. So, question dito, parang may prejudicial question ba? Parang ganun. So, may prejudicial question ba, guys? Prejudicial, meron ba? Hindi ko maisip kung meron. Parang sabi, kukwestiyonin mo muna kung legal heir ka. Halimbawa, ano ba, anak ka ba talaga ni Rodrigo? Ganun. Bago niya ma-enforce. Well, kung sino nag-a-allege siya mag-prove. So, ibig sabihin, if, may presumption muna. Ano ba yung presumption? Ang hirap naman sagutin. Sige. Ano mo nang sagot? Pabalikan na lang kita. Wala akong mag-efficient. Wala akong makatapos ka agad, guys. No. As ruled that unless there is a pending special proceeding for the settlement of the decedent's estate, compulsory or intestate heirs may commence an ordinary civil action to declare the nullity of a deed or instrument and for recovery of property or any other action in the enforcement of their ownership rights. Okay. So, hindi daw kailangan. Wala nang kailangan prior and separate judicial declaration of their status as such. So, matik na ibig sabihin, the compulsory or intestate heirs may commence an ordinary civil action for the declaration of nullity of a deed or instrument or for recovery of property or any other action in the enforcement of their ownership rights by virtue of their succession. Okay, so ibig sabihin, the way I understand it is, upon the death of the decedent, nabawa si tatay namatay, yung mga anak already steps in officially and presumptively by the law. Legally, they're already stepping into the shoes of their father and now they can file cases for the transactions their father entered into and to like do that, like declare the nullity of some sales or deeds or to recover some property of their dad or any other actions that needs enforcement actions for the ownership of their dad. So, hindi siya kailangang i-determine. So, ibig sabihin, if there is another case, so ngayon, pero ang exception dun is kung may pending ng special proceeding. Okay? So, ibig sabihin, kailangan mag-start sila ng ordinary civil action bago mag-start yung special proceeding. Kasi once nag-start yung special proceeding, that is somehow barring them. Or it can be like a prejudicial question as to whether they can exercise ownership rights. So, sige. Next. 7 minutes. Bilis. Namjoon. Okay. Si Namjoon. Okay. Sabi si Namjoon. Si Namjoon, Korean, si Regine, Filipina, kinasal sa Makati, 2012. Tapos, nag-divorce sila sa South Korea. No? The local court of Korea granted the divorce. So, ngayon, gustong pakasalan ni Regine si Taeyong. Nag-file siya ngayon na recognition of foreign decree divorce in RTC of Cebu. So, the Office of Solicitor General opposed the petition, contending that proper remedy is a special proceeding for cancellation or correction of entries in civil registry under Rule 108 of the Rules of Court. Bakit Rule 108? No. No, the OSG contention is not tenable or untenable. Under the law, under the family code, what is required for the recognition of the decree of foreign judgment is to prove the same in the local courts. Additionally, Rule 108 is a special proceeding for the correction of errors which does not, hindi ako na mag-additionally. Sige, kita muna natin yung additionally na yan. Here, The case is not about errors. O sige, tingnan natin. And not the declaration of and not for the specific purpose of recognizing divorce. Foreign decree of divorce. Here, the case is not is wag natin sabihin kung not about is uh, on the issue of recognition of foreign decree of divorce. Hence, the OSG's contention using 108 is not untenable. For this case, is not an issue of errors in the entries. Okay, sige. Okay na yan. Tama si OSG. OMG. Supreme Court has ruled that in the interest of judicial economy and simplification, parties in interest who seek not only to have a foreign decree must file a petition under Rule 108 in relation to Rule 39. Okay. Coupled with judicial recognition. So, verily, a petition for a judicial recognition for divorce shall be filed in the province where the here, Regine not only wanted to have a foreign divorce with okay. Teka. Sinabi niya sa Makati, hindi sa Cebu. Kailangan ko manoto. Saan sila kinasal? Kinasal sila sa Makati. Ngayon, nasaan yung Cebu? Doon siya nag-file sa Cebu kung saan siya nakatira. Dapat ipa-file mo siya kung saan kayo kinasal. Okay? So, mag-file ka sa Makati under Rule 108. O, di ba? Matatandaan ko ngayon to, guys. Mali ako. Sige. Kaya nga tayo nag-aaral. Kung tama na pala ako lahat dito, mag-bar na tayo. Kung tayo mag-aaral. Thank you. Meron tayo nakuhang na-correct na. Ang ibig sabihin nun, we're getting closer to that ATTY, guys. Yun ang mindset. Nagkamali ka, good. Ibig sabihin, effective yung pag-aaral mo, may na-correct ka. Tumama ka, good. Ibig sabihin, ready ka na. Either way, good. Papasa ka na as an attorney. That is the mindset, guys. Sige. Notting Hill Court filed an action for forcible entry against 10 occupants of a parcel of land it owns. Okay. Ang tanong lang, pwede bang implement niyo yung date of execution against the lessees? So, nag-file si defendants ng notice of appeal pero hindi sila nag-file ng supersedeas bond. The failure of the Notting Hill Corp to, the failure of the defendants to file a supersedeas bond means it will not stay the judgment to vacate. So, when you implement the rate of execution against the lessees, yes, you may implement the rate. Okay, under the rules, a supersedeas one may be filed by the opposing party pending appeal to stay the judgment. The execution of a writ of ano to? Execution. Writ. Here, such supersedious bond was not filed. Hence, the writ may be minted by the sheriff, by you. Okay. So ang issue na tinakal dito is yung lessee or sublessee. Ang issue na tinakal ko is yung non-filing of the supersedious bond. Dapat gumaling pa ako sa issue tackling. No? Hindi ko nakita yun. Pero if the question, if the question really was about dapat tinakal ko din yun. Kasi ang tanong, proper implementation of the writ of execution. Dalawang issue na nakikita ko. Number one is failure to file the supersedious bond. And secondly is I'm just a lessee standing in front of a sheriff. So the question is a sublessee also can you implement a writ of execution against the sublessee? The answer is yes. Pag ganito kasi issue spotting yung problema eh. Pero at least nakita ko ngayon na improve natin no guys. So dapat i-discuss ko din sana siguro yun. Kung yun yung dalawang issue. Either way, kung anong issue doon, nasagot ko. Eh well, move on na tayo dyan. Next, 9 minutes. Ang clear ng tanong. Tagal ko nag-analyze. Okay. An information for murder was filed against the accused Demo and Onyok. It reads that on or about the 9th day of March 2008, the city of Las Piñas, Philippines, and within the jurisdiction of this honorable court, the above-named accused, conspiring and coordinating together, and both of them mutually helping and aiding each other without justifiable motive, with intent to kill, and with treachery and abuse of superior strength, did then and there, knowingly, unlawfully, and feloniously attack, assault, and use personal violence upon Angel Rosario by then and there repeatedly hitting and beating his head with a baseball batter by inflicting upon the latter mortal injury which caused his death, contrary to law. The accused filed a motion to quash on the ground that infirmage does not conform substantially to the prescribed form. So ano ba yung issue dito? Form daw. Tingnan natin. Form. Sa form, ano bang form na hinahanap? So ibig sabihin, the allegations in the complaint dapat kompleto. On or about 9th day of March. So nandun yung date. Location, where, when. Philippines. Okay. Who? Okay. How? Conspiring and confederating together, and both of them mutually helping and aiding each other without justifiable motive, with intent to kill, and with treachery and abuse of superior strength. Pinagsama-sama na lahat. Did then and there knowingly, unlawfully, and feloniously attack, assault, and use personal violence upon one Angel Rosario. By then and there, repeatedly hitting and beating his head with a baseball bat, thereby inflicting upon the latter mortal injury which caused his death. Ano ba yung issue dito? Kulang ba yung information? Ano ba to? Hindi sinabi kung ano yung offense charge. Ano sinabi kung homicide, murder. Ano ba to? Physical injuries. So, or ano ba to? Physical injuries resulting to homicide ba to? Okay, sige. No. Yes. Say yes. The accused is correct. Under the rules, the offense charge must be categorically named in the information. Here, there was no allegations as to the crime charged to the accused. Hence, the accused is correct in filing the motion to quash. Mali yung accused. Ah, mali ako. Ano ba to? Name. O, nandun yung name. Yung designation. Nasaan yung designation? Ano ba? Mortal injury which caused his death. Yun ba yun? Oh. Oh, tapos, acts or omissions complained of as constituting offense. Plus qualifying aggravating. Okay. Name of the offended party. Okay. The approximate date of the commission of the date. Okay. The place. Okay. Nabanggit ba lahat? Pero hindi ito yung designation of the offense given by the statute. Anong case ba to? Hindi ko alam. Saan ba yun? Thereby, name. Kasi ito, sige nga, gawan mo nga ako ng maaalala kong ano, create a mnemonic for this. Okay. Okay. No dogs act near dirty places. No dogs act near dirty places. Name. Designation. Ano yung A? Acts or omissions with qualifying and aggravating circumstances. No dogs act near. Name of the offended party. Dirty D. Date. Approximate date of commission. And places. Place where the offense was committed. Oo naman, no dogs act near dirty places. Ang galing. Sige nga. Okay. Can you try Tagalog and Taglish? Pag Tagalog and Taglish. Pangalan, delikado, aksyon, biktima, pet sa lugar. Ang pangit naman. Name. Ang hirap naman. NDAVDP. I prefer the English one. It makes sense. I'm looking at the information for the accused. No dog. Ano sabi mo? No dogs act near. No dogs act near dirty places. Makes me remember that this is related to the accused. Yeah. Okay, no dogs act near dirty places. Okay, sige. Copy natin to. Paste. No dogs act near dirty places. Copy natin to. Ito ba yung check na kakakopy dito? Oh, galing. Okay, sige. No dogs act near dirty places. By the end of us studying these questionnaires, we should be able to come up with a list of mnemonics na pinagdaanan natin during all these reviews. Magpapaalala sa atin, paano natin sasagutin yung bar exams later on. Okay? Sige. Gano'ng katagal kong kinuha yun? Lap. 7 minutes lang yun. Mabilis pa rin sa kanina. O sige, game. O si Kane naman ngayon, murder. Bible naman. Diba? Napaka-creative ni Attorney Jeep. Jury. Ito yung jury. Kane was indicted under an information charging him with the crime of murder. He was caught by the police in flagrante delicto. O, nahuli siya. Caught in the act, red-handed, nung nangyari sa public at ang daming witness. May mga videos pa online nakita ng judge. Nung na-arraign siya, nag-plead si Kane to the crime charge. So sa RTC, inaccept niya yung plea kasi nga voluntary naman and alam naman niya yung consequences. Now, sabi ng RTC, mag-present ka ng evidence para i-prove mo yung guilt ni Kane. Sabi ng prosecution, yung prosecution, hindi sila nakapag-present ng evidence. So, ngayon, sa RTC nag-rule na guilty beyond reasonable doubt based solely on his plea of guilt. Okay. A crime of murder, guys, ang usapan. When the crime charge is punishable by reclusion perpetua or death, or the capital offenses, capital punishments, then proof beyond reasonable doubt has to be proved with evidence and not solely on the plea of guilt of the accused. Okay, lagyan natin siya. Question. Was Kane's conviction proper? Of course, no. 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 The conviction of Kane was not proper. Under the rules, when the crime is punishable by reclusion perpetua or death, the plea of guilt may not be the sole baliktarin natin. The guilt beyond reasonable doubt of the accused must still be proven regardless of plea of guilt entered by the accused. Here, there was no evidence adduced to prove the guilt of the accused, and the conviction was held solely based on the plea of guilt the accused. Hence, the conviction is not proper for lack of proof beyond reasonable doubt. Okay. No. Capital offense. Capital offense pala dapat. Hindi na lang punishable by Okay, capital offense. Pag-uwi natin yan, so dapat i-enter yung judgment of acquittal in favor of the accused. Sige, okay na yan. Siguro medyo, 3-4 points man yan. Sige. Move on. Bilisan natin. Hindi pwedeng pabagal-bagal tayo, guys. Okay. That was 3 minutes, 50 seconds. Enumerate, describe. Ito yung mga question na ayaw ko. Enumerate and describe 3 warrants that will be issued by the courts pursuant to the rule on cybercrime warrants. Guys, enumeration 2. Ayoko ng mga ganitong tanong. Wala akong nasasaulo sa inaaral ko sa batas. Hindi ko kaya. Copy-paste na lang natin to. Balikan na lang natin mamaya. Ano ba to? May gano'n naman kasi. Pangit ka banding. 1. Paano ko maaalala to? Kailangan ba ito sauduhin talaga? Paano ko lumabas sa bar? Hindi yari ako. Alam ko bar questions talaga to eh. Kailan ba ito lumabas? Remedial 2022 1-12. Number 12. Diyos ko. Lumabas siya sa bar, guys. Sige, sauduhin natin. Disclosure of computer data, interception of computer data, search and seizure and examination of computer data. Ano to? DIS. Sige nga, pagawa natin kay ChatGPT. Create mnemonic. O, di ba nalaman niyo yung 3 types of cybercrime-related warrants? Galing, galing. Galing mo O, sige. Don't investigate without search. Ang galing, guys. Don't investigate without search. Okay, don't investigate without search. Galing, 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 galing. Okay. Lagyan natin yung susi para maalala natin. Oh, di ba? Disclosure. Warrant to disclose computer data. Investigate. Warrants to investigate, to intercept computer data. Dapat hindi na lang will don't disclose, intercept, search. Don't investigate without search. Disclosure, interception, warrant to intercept computer data. And then warrant to search, seize, and examine computer data. Sige. Whew, let's go. Let's go. Game. Next. 3 minutes na spend natin doon, guys. Kailangan mabilis pa. Bilisan pa. Moto. Wiki. While driving his Maserati smashes into the Toyota Vios of Dante immediately after the incident. Ricky offers to pay the value of the Toyota Vios. Dante still sued Ricky criminally for reckless imprudence because of Ricky's wayward and speedy driving. During trial, Dante was called as witness to testify on Ricky's offer to compromise on the submission of guilt. Ricky's counsel objected. Okay. Oo nga. Nang problema sa atin kapag nag-offer ka ng compromise, guilty ka na If I were the judge, I would overrule Ricky's counsel's objection under the rules, or as decided by the Supreme Court in the case ba to? Sige, under the rules. The offer of compromise is an admission of guilt. Hence, here, Vicky offered a compromise to Dante. Hence, the objection of Vicky's counsel must be overruled as the compromise was an implied admission of guilt. I will sustain. Overruled ba? Sustained? Sino ba si Ricky's counsel objected? Si Ricky ang nakabangga. Si Dante ang nabangga. During the trial, tinawag si Dante as witness, yung nabangga, to say na si Ricky nag-offer ng compromise. Sabi ng counsel ni Ricky, I object, Your Honor. Objection. Baka hindi ko naintindihan. Overruled versus sustained. Ano ibig sabihin? If the judge overrules the objection, they disagree with the objection and allow to be admitted. If the judge sustains the objection, they agree with the objection and disallow the question. So ngayon, sabi dito, Okay, quasi-offense. Ito, criminal cases, except those involving quasi-offenses. Okay. Tandaan mo, Carla, hindi lahat ng compromise ay admission of guilt. There is an exception, and when it is a quasi-offense or other um, or others or those allowed by law to be compromised. Hindi lahat. Carl, tandaan mo yan. Ha? Big bossan kita. Big bossan talaga kita. Sige. Next. So, next. Here. Okay, sige. Next. Up. 4 minutes. Okay. Klaus was drinking in front of his rented apartment when he suddenly heard a gunshot which came from inside the apartment by Luther. Klaus then saw Igor, a neighbor, going down the stairs and leaving the scene holding a gun. To Luther when he fell. During Igor's trial for murder, Vanya testified, presented a flash drive CCTV. Said for the show the man appeared to be Igor armed with a gun proceeding upstairs. And in the video, the same man was seen as leaving prospect that she was the one who transferred to the flash drive the video footage from the barangay on CCTV that was located outside the apartment. When the footage was played in court and a large screenshot was presented, Vanya testified the shooter as Igor. The defense objected on the ground that Vanya was not the recorder of the video footages. Admissibility lang pala eh. Dali lang yan. Hindi mo na kailangang isipin. Minsan talaga dapat dumidiretso ko na lang sa tanong eh. Diba? Protect. Admissible to in general. Okay. Ulit. Okay, I may answer yes. The CT footages are admissible under the rules on evidence or under the rules. CTV footages are electronic evidence are admissible in court. Here, CCTV footage is offered as, ano spelling na offered? Double, tama ba? Offered. Ano spelling? Offered. Isang R lang. Card. Offered as evidence. CCTV footage is counted as an electronic evidence under the rules. Hence, the CCTV footage is visible in evidence. Yun lang naman tanong. For the admissible videos should be so are displayed to the court. Okay. Ang issue dito is, can someone, not the person who recorded the CCTV footage, testify to the accuracy of the CCTV footage? Provided that it shall be shown, presented, or displayed to the court, and shall be identified, explained, or authenticated by the person who made the recording, authentication by the person who made the recording, or some person competent to testify on the accuracy thereof. So, kailangan mo matandaan na in order for video recordings to be admissible in court, it must be identified, explained, or authenticated by the person who recorded it or some other person who is competent. Or by some other person who is competent to testify on the accuracy thereof. Here, it was established that Vanya was the one who transferred the video footages from the barangay-owned CCTV that was located outside their house to the flash drive that was submitted in court as evidence. Anong kinalaman na pag-transfer? So, the Supreme Court, in one case, elucidated the persons authorized to authenticate the video or CCTV recording is not limited solely to the person who made the recording, but also by another witness who can testify to its accuracy. Okay? In People versus Concepcion, the Supreme Court clarified that the case of Manansala requires the party presenting the recording to account for its origin, how it was transferred to a storage device, and how it reached the trial court for its presentation. So, required din na kailangan malaman mo yung origin, how it was transferred to a storage device. So, saan nanggaling? So, kapag presentation ng CCTV evidence, ang kailangan tandaan natin is that number one, its origin, how it was transferred to a storage device, which is a flash drive or whatsoever, and then until it reached the trial court for its presentation. So when you're presenting CCTV footages, as to admissibility, you have to check. That's electronic evidence, but there must be some way provided that it shall be shown, presented, or displayed to the court, and it shall be identified, explained, or authenticated by the person who made the recording or another person who is competent to testify as to the accuracy thereof. Okay, that's one. And another requirement is, in another case, to determine the source of the video, how it was transferred to the mode of transfer. Ano ba to? It was transferred to storage device until such time that it was presented to the court as evidence. So, yun dapat matandaan, Carl. Sige. Sana matandaan natin. Babalikan ka namin, Vanya. Sige. Balikan natin si Vanya. Here, Vanya. Gusto ko na matapos. Next. Ay, break na pala ako. Isang oras na tayo. Isang oras na yan. Yes, 1 hour na yun. Ang bilis-bilis. Pahinga tayo ng 5 minutes, guys. CR lang ako. Ilang puno yung natanim ko doon? Teka, start pa lang. Ilang puno yung natanim natin? 2? Sige, game. Okay, back to aral, back to aral. Game guys, back to aral. Yung kasi makita yung mic ko. Yung video mic ko. Yung Rode video mic Go 2. Okay, game. Okay, game. Tanim tayo ng puno. Cute pala nun, no? Meron palang ganun yun. Oh. Yung palang mga puno dito. 120 minutes pala para makabuo ka ng isang punong full adult. Okay. Itong bata. Gusto ko yung maraming stages yung puno. Okay, sige. Gawa tayo ng 2 hours na puno. So, 2 hours na puno. Yan. Gusto ko yung 2 hours na puno kasi may alien siya. Game. In case for estafa, the prosecution offered the photocopy of the acknowledged. Tapos na yung ating pahinga. Nagpahinga tayo 8 minutes. Sobra tayo sa 5. In the case for estafa, the prosecution offered the photocopy of acknowledgement receipt signed by the accused, showing personal receipt of the sum of money from the private complainant to prove the amount of damage. Accused objected to the offer of the photocopy on the sole ground that it is a mere reproduction of the original in violation of original document rule. Oh, photocopy yun. No, did not air. No, the court was correct in admitting the photocopy under the original document rule. Photocopies which are the exact reproduction of the original when properly authenticated may be admitted as original evidence. Here, the photocopy submitted was authenticated by the accused by virtue of his signature. Hence, the photocopy may be recognized as original evidence, and the court was correct in admitting the same. Ah, talaga ba? Photocopy in evidence. Okay, teka lang. Hanapin ko lang yung reviewer ka ng ano. Ano nga to? Paste. Ito. So, ang sabi dito, dagdag ako ng source. Teka lang. Tignan natin. Okay, dagdag tayo ng reviewer. Tapos, kunin natin itong ito. Sabi dito, napin natin. Original document rule. Original document. Hindi ko makita. Evidence. Okay. Original documentary evidence. Admissibility of evidence. Saan pa tayo? Documentary evidence. Ito. So, sa documentary evidence, if the original document is available, present the original. However, if the original is not available, the next best, secondary evidence. Tapos, ang sabi dito, ito. Data is original. An original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. So, data is original if stored in a computer or similar device. Print out, other output readable by sight, other means shown to reflect it. Duplicate, photocopy, ayan. Same impression or of the original. A duplicate is technically not an original but is treated as such. It is a functional equivalent of original. It is admissible to the same extent as the original unless there is a genuine question is raised as to the authenticity of the original. And in the circumstances, it is unjust or inequitable to admit a duplicate in lieu of the original. May question bang raised as to the authenticity of the original? So, ang tanong. Okay. So, balikan natin ngayon yung kanina. Ang question. Ang tanong, sabi niya, totoo ba? It is a mere reproduction. There was no question as to the authenticity of the original document. There was just an objection as to having been a mere copy of the original. So, in that case, there was no genuine question raised as to the authenticity of the original, and it is not unjust or inequitable to admit a duplicate in lieu of the original. Therefore, a duplicate, even though not technically an original, it may be treated as such. It is a functional equivalent of the original. So, admissible siya. Okay, so there might be some weight to how I answer So, pero mali lang yung ano ko dito. Dapat parang sinabi ko na a photocopy is a duplicate, and even though it is not an original, it is treated as functionally, ano sabi dun sa reviewer? Functionally, a functional equivalent. So, dapat ganun yung terminology ko. But anyway, medyo naitawid natin. Feeling ko kahit iba yung sagot, pero feeling lang yon. So, kung malito. Kung ito talaga yung tamang sagot, so be it. Pero, yun nga, the same case, minsan, iba naman talaga yung sagot ng mga top-notchers dun sa mga suggested answer. So, and doesn't necessarily mean na mali ka na. Pero, ay, medyo nangonigo naman tayo. Medyo reasonable naman yung sagot natin. Tignan natin kung paano siya pero wala tayong way para malaman kung tama ba yung pagsagot natin, pag-view natin. Pero we can improve on that one. Yung by mentioning na may functional equivalent or duplicate ang photocopy and is a functional equivalent, and basta yun. Okay yan. Next. We took 7 minutes on that one. Next question. O, diba 48? Okay. Sige. Assume that you receive an adverse decision and file a motion for reconsideration which was denied. Okay, give... Reglementary. Talagang literal na ano to. Rules of procedure. Alam mo yung mga reglementary period na yan. Guys, tagdaan nyo. It's reglementary, hindi reglementary. Okay, sige. Sagutin natin. Dito yung kainaan ko, yung mga definition, yung mga objective type na question. Hindi mo mabola. Notice of appeal to the Court of Appeals. Natapos na yung motion for reconsideration. Fresh period rule applies, tama ba? So, 15 days from the entry of judgment. Okay. Under Rule 65, no reglementary period. Court. Petition for review to the Court of Appeals under Rule 42. Rule 42. Ano ba yun? From administrative ng mga kuha sa judicial, kunyari 15 days din. Same ng letter A. 15 days, lahat 15 days. Rule 64. Sige na, 15 days. Kunyari 15 days lahat. Sabihin mo sa akin ang sagot. 15 days from notice of judgment or final order. Meron palang Rule 65. Not later than 60 days counted from the notice of the denial of the motion. Okay. May reglementary period din pala yun eh. Okay, so dapat i-mention mo din yung denial of motion for new trial or motion for reconsideration. Okay, iba pa pala to. Ito naman, 15 days from notice of judgment or final order or the denial of the petitioner's motion for new trial or reconsideration filed in due time after notice of judgment. So, same sila nito. Okay, tapos yung letter E, within the remaining period, max of 30 days, but which shall 64. Ito ata yung sa sa quasi-judicial, no? 64. Hindi ko alam. Sige na nga, tingnan natin. Ano ba to? Ito lang ba yung amendments? O nandito yung lahat? Amendments lang to. Hey! Rules, civil procedure. Siyempre. Ito tayo dito. Rule 65. 64. COA. NCOE. Ang Rule 65, of course, is our petition for review on certiorari. Okay. Prohibition and mandamus. Tapos, Court of Appeals under Rule 42 is from RTC to Court of Appeals on, I think this is on, okay, yung regular appeal. Tapos, Rule 45 from CA to Supreme Court naman to. Appeal by certiorari to the Supreme Court. Okay, tas yung E naman. Okay, sige. Okay. Copy-paste. Naging bar question to. Grabe naman. Subjective. 2022. Kailan po? Kaya ko pa naman mga subjective na tanong. Wala akong sinasa ulo sa Ewan ko paano ko pinasa yung law school nang wala akong masyadong sinasa ulo. Natandaan ko lang, tapos tinatry ko intindihin, hanggang paulit-ulit lang, hanggang maalala natin, pero hindi ako nagsasaulo talaga na, ito dapat. Anyway. Sige. Okay na yan. Next, I spent 4 hours, 55 minutes. 4 minutes, 55 seconds. Okay, next question. Okay. Did Gail take the correct mode of appeal? So, ang question. Forcible entry complaint against Marianina, MTC ruled in favor of Marianina. Gail appealed to METC to the RTC. The RTC denied Gail's appeal and sustained the MTC. Filed a notice of appeal with RTC. I-appeal niya to the CA. In her notice of appeal, Gail also requested the RTC to transmit the records of the case to the CA. Mode of appeal. So, a mode of appeal. Kasi dalawang mode of appeal. RTC in the exercise of original exclusive jurisdiction to the CA, and RTC in the exercise of its appellate jurisdiction. Dito, appellate yung sinusundan natin. Okay, so hindi ko masyadong sa ulo kung anong rule specifically. Pero kasi to, kasi diretso na to na, kapag appellate jurisdiction na, it depends. If there's a question of facts, is there a question of facts? Hindi. Siguro dapat na to, Supreme Court na to. Wala natin, no. No. Supreme Court dapat. Hindi ko alam kung anong tamang sagot. Rules on expedited procedure na pala to. Summary procedure kasi to. So dapat Rule 65 na siya sa 6SC. Tama. Tama tayo. Di ba naalala natin yung appellate jurisdiction? Tapos, ang hindi natin naalala is summary procedure and forcible entry. So, final executory and appealable na yun. Dapat nag-65 na with the CA. Not off. Okay, gets. Parang kung ako yun, bigyan ko ng 1 point for the effort kung inargue ko to ng buong sagot na tumama yung no. Si dapat. Siguro mga 2 to 3 points to. Kung sinagot ko ng buo. Pero anyway, we save time. That's just 2 minutes, 36 seconds. Okay, next. RTC rendered a decision against Kat. She received a copy of the decision on December 26, 2021. Kat's counsel filed with the Supreme Court a petition for review on certiorari under Rule 45 by registered mail. Okay. The petition was dismissed for failure to pay the docket fee. Counsel challenged dismissal. Intention was to pay the docket fee after the same is assessed upon the court's receipt of the petition by registered mail. And dismissal of the petition effectively rendered nugatory a party has the right to appeal by registered mail under the rules. Kat's counsel that she did not want to include cash money in the mail. Okay, answer no. Kat's counsel is incorrect. Under the rules, in order to perfect an appeal, there must have been a proper issuance of notice of appeal to the proper court and the payment of the corresponding docket fees. Here, the notice of appeal was filed via registered mail. However, payment of docket fees was not done. Hence, there being no compliance to the payment to requirements above, the appeal cannot be perfected, and thus petition speeds the dismissal of the appeal. Though, no, kapag ganito, minsan magiging maluwag yung court. Pero if you look at the technicalities alone, without subjectivity of the court, pwede na to. Okay na to. Okay. Oh, di ba? Pwede na to. Pwede na to, guys. Pwede na yan. Okay na to. Next. Pinakabilis. 3 minutes, 2 seconds. O, di ba? ADR. Ito, to. Hindi ko alam itong mga ganito. ADR. Siyak. Submitted their construction dispute to arbitration in the SIAC in 2022, March. They rendered an award in favor of Kasanga. What is Matibag Realty Corp's remedy? Oh, kapag meron kang arbitral tribunal, that is binding upon the parties. So, ano na lang ang recourse mo? Motion for reconsideration. Or diretso ng 65. Kailangan ko ba mag-MR bago ako mag-65? Kailan ka ba mag-rule 65? There must be, there's no other just, speedy, and effective means. My answer. Matibag, Realty Corp, may file motion for reconsideration. Under the rules, hindi na rules, under the law. Hindi ko na alam kung anong law, pero under or as decided by the Supreme Court, the decision of an arbitral tribunal is final, executory, and unappealable. Hence, the proper remedy is a motion for reconsideration and the subsequent petition for review on certiorari under Rule 65 if the motion is denied. It's the proper mode. It's the proper remedy. The proper remedy is denied. Period. Here, there is already a final judgment award by the SIA as to the arbitrating parties. Hence, motion for consideration and subsequent petition for review on certiorari under Rule 65 is the proper remedy. Okay? Sige. Okay. Anong sagot? Rule 43. Oh, tek. Rule 43. Ano ba yung Rule 43? Court of Appeals. Rule 43. Appeal from Court of Tax Appeal and quasi-judicial agencies to the Court of Tax Appeals. Ganun. In the case, as ruled by the Supreme Court, the losing party has two recourse options. File an appeal or pure questions of law directly to the Supreme Court within 15 days, pursuant to Rule 45, or to file a petition for certiorari to the Court of Appeals, pursuant to Rule 65. Oh, ba't magkaiba yung sagot? Bakit mag-petition for review ka under 43? Tapos dito sa baba, 45. Pag Rule 45, questions of law. Or certiorari to the Court of Appeals, Rule 65. Anong sagot? Pili ko 45 to. Sige. Pili ko 45 yan. 45 to the Court of, hindi, Rule 45 to the Supreme Court. 65 to the Court of Appeals. Pero tama na yung 43 is Court of Appeals. Check natin. Ibang cover nito. Court of Tax Appeals. And from award judgments, final orders of authorized. Among these agencies, tingnan natin dito yung SIA. May arbitration something ba dito? Ito, SIA. Tama. Rule 43, guys. Tama. So, mag-a-appeal ka muna ng Rule 43 to Court of Appeals. Pero sinabi din dito sa Global Medical Center of Laguna that you can appeal on Rule 45 to Supreme Court. So, ibig sabihin, dito, 43. Kasi hindi naman siya pure question of law. But if pure question of law, Rule 45. Or, kung feeling mo naman is walang jurisdiction, grave abuse of discretion about to lack or excess of jurisdiction, then Rule 65. But in this case, mukha namang walang ganun. There's facts. So, parang tatlo yung remedy mo pala. 43, 45, 65. Okay, matatandaan kita. Okay, next. 6 minutes. Next. NYSA was defrauded by Jackie, resulting in damages to former NYSA filed a civil suit before the RTC. The RTC dismissed her complaint. Within 4 years from NYSA's discovery of dismissal of her complaint, she filed to her counsel a petition for annulment of judgment under Rule 47 before the CA on the ground of fraud. No. Annulment of judgment is filed with the body who ordered, the court ordering. So, dapat sa RTC siya, no, the CA should not give due course. Under the rules, petition for annulment of judgment. Pero teka to. RTC dismissed her complaint. Within 4 years from NYSA's discovery of the dismissal of her complaint. Okay. She filed through her counsel a petition for annulment of judgment on the ground of fraud. Okay. So, ang issue talaga dito is, tingnan mo, anong issue? Ano yung pinaka nasa dulo? Ground of fraud. Rule 47, petition for annulment of judgment. Rule 47 of CA. Question, tama ba yung Rule 47 of CA on the ground of fraud? So firstly, under the rules, petition for annulment of judgment must be filed with the court whose order is being prayed for annulment. Hindi ko alam kung tama yung grammar ko doon. Sige, kunyari tama yung grammar. on the basis of fame. Sige, okay na yan. Here, the petition for annulment judgment was raised to the CA. And that is the question. Should CA give due course? Hence, the CA shall not give due course as it is not the proper court to file the petition for the annulment of judgment. Okay. O, anong sagot? This is will be based on ground adjustment void per warrant of restriction or that it was extrinsic fraud. There is extrinsic fraud when the petitioner was not given an opportunity to present his or her side. Here, it was nice that filed the civil suit. As a plaintiff, she should have known the prognosis of her case. There is no indication of extrinsic fraud for ground for annulling the judgment. The petition should therefore be dismissed. Okay. It is a presumption pala. Actually, yun yung iniisip ko. Hindi mo alam nangyayari sa case mo. Ano ba yung abogado mo? Hindi ka na-update? Ano? Natulog na lang kayo? Hindi pwede yun. Hindi mo alam na dismiss, hindi ka nag-follow up. Alaman mo lang 4 years later, nagising ka, nasa bundok ka. Nabash. Okay, anyway. Kailangan bilisin. 3 minutes 28 seconds. Okay, next. Si Alex, yan na. 4 sisters. Alex, Bobby, and Gabby were charged with the crime of murder, finding them to have been may conspiracy in the RTC for the homicide. Only Bobby appealed the conviction with the Court of Appeals. Consequently, an entry of judgment was issued as against Alex and Gabby. Subsequently, the CA modified Bobby's conviction from homicide to murder. In the same judgment, the CA likewise modified Alex and Gabby's conviction from homicide to murder. Upon learning of the CA's decision, Alex and Gabby confronted Bobby saying, "Bakit ka ba nag-appeal? Tumaas to lang suspension namin, nadamay pa kami. Bakit parang galit kayo? Bakit parang Bakit parang galit? Bakit parang kasalanan ko? Bakit parang kasalanan? Ususi ko rin mo as to Alex and Gabby. No. Kasi dito, nag-appeal siya. So, si Alex, si Bobby, na nag-appeal to CA, so nagkaroon na ng judgment kay Alex and Gabby. So homicide lang sila. Ngayon si Bobby naging murder. Tapos binodify naman ngayon sa baba from homicide to murder. Mali 'yon. Siguro kung pababa yung sentensya pwede. Bakit parang salaan ko? Yes, no. The CA is not correct. Under the rules, as decided by Supreme Court in a case na lang to. As decided, may ganitong case by the Supreme Court, the conviction of co-conspirators in the lower level courts that reach finality shall not be disturbed nor modified except when such modification is favorable to the accused. Here, the conviction of Alex and Gabby should have been sustained and not modified by the CA since it was not in favor of the co-accused. These two accused. Hence, such modification is barred by res judicata by final judgment, and the doctrine of immutability of judgment shall be applied. Hence, say is incorrect in modifying the judgment as to Alex and Gabby. Okay, tignan natin. Oh, 5 points. 5 points, guys. Salamat mga kababayan. 5 points tayo. 5 points yun, ha? Hindi ko lang kung 5 points. Sana. Mabait sila mag-appreciate. Nagdadasal ko na lang na appreciative talaga ang courts. That was 4 minutes and 27 seconds. Let's move. Mayor Dalupan. Mayor Dalupan, who was notorious for being involved in public readings, was convicted by San Diego Mayor violation of 3019. State of Mayor Dalupan filed 65 on the 59th day from notice of the assailed and San Diego Mayor ruling. Okay. Is the remedy bill for correct Anti-Graft and Corrupt Practices Act. Na-convict na siya ng Sandigan Bayan, original jurisdiction. So dalawa yan. Kapag appeal from the Sandigan Bayan, is it an appeal from an administrative order or in the exercise of regional jurisdiction? Okay. So ito 3019 vests with the Sandigan Bayan exclusive jurisdiction as to Anti-Graft and Corrupt Practices Act. Okay. Pero, okay, hindi naman issue kung magkano yung tonnage. So, Rule 65 petition for certiorari before the Supreme Court. Well, kanina natutunan natin na 60 days yung reglementary period for the filing of Rule 65 from the assailed decision. Tama ba yun? Yes. Kasi bakit? Wala na bang ibang expedient? Hindi dapat ng final siya. Meron pa namang di ba? Sandigan ba yung Rule 43? No. The remedy availed is not proper. Under the rules, Rule 43, under Rule 43 of gumagaling. May Rule 43 na tayo ngayon, hindi na under the rules. Di ba, nag-evolve tayo, guys. We're evolving as a person. We're growing as a bar taker. Under the Rule 43 of the revised rules on civil procedure. Under Rule 43, the Sandigan Bayan, the proper mode of remedy for appeals on the judgment rendered by the Sandigan Bayan in the exercise of its exclusive original jurisdiction is to file under the rules notice of appeal with the CA under Rule 43. Dapat under the rules na lang to. Here, the remedy availed of here, the case was filed in Sandigan Bayan as an exercise of its regional and exclusive jurisdiction vested upon it by the law under RA 1319. Hence, the proper mode of appeal is under Rule 43. Okay. Tingnan natin. Decision shall be appealed to Supreme Court by petition for review on certiorari. Rule 45. Question of law. Question of law ba to? Hey. Ano ba yung, ano nga ba? Tama ba yung 43 ba to? Nandito ba yung Sandigan Bayan? Sandigan. 45 pala. Sandigan Bayan. Potek. 45 naman pala talaga tama. Tapos, nasan yung 45 days? Pag pure question of law. Pure. Ano ba yun? Sige. 45 tayo. May reglementary period. Basta tandaan mo, 45 days. Within, 15 days. 15 days from notice of the sale ruling to file the rule 45. Okay. Rule 45. Mali ka, Carl. At least tama yung no. Pero mali. Mali yung basis natin. So, alam mo, mabigyan ka ng 1 points. 1.2 points. Anyway. Kailangan ito magmadali. Clap. That's 5 minutes, 53 seconds. Masyado tayo nagtagal doon. Si Migit Laida. Mahilig ka manood ng movie sa Attorney Gibb. Red Gibb. Okay, sige. Si Laida magtalas. And I found a very special love in you. Okay, sige. Police officers Miggy and Laida were involved in alleged bypass operation against Mr. Magtalas, a suspected drug dealer. Mr. Magtalas maintained his innocence, asserting the drugs were merely planted. He further claimed that he was unjustifiably beaten by the police officers, filed before the office of the ombudsman a criminal complaint for planting evidence. Okay. Mr. Magtalas also filed an administrative complaint for grave misconduct against Miggy and Laida in light of the unwarranted physical assault against him. The office of the ombudsman rendered a decision holding Miggy and Laida administratively liable. Okay. A few weeks later, the OMB issued separate resolution that there is probable cause for violation of 9165. Aggrieved, Miggy and Laida filed before the Supreme Court the following. So, a Rule 65 petition for certiorari for assailing the jurisdiction of the OMB. And Rule 45 petition for review on certiorari assailing the OMB's resolution finding probable cause against them. Okay. Question, tama ba yung Rule 65 at Rule 45? Okay. Rule 65 is based on grave abuse of discretion amounting to lack or excess of jurisdiction, while Rule 45 is raising to the Supreme Court on pure questions of law. Okay. Rule 65, ina-assail niya yung decision ng OMB kasi nga administratively liable for grave misconduct. For administrative, for rulings on administrative liability, paano ba to? By the ombudsman, paano ba? Hindi ko rin matandaan. Okay, copy-paste na lang natin. Hindi ko ma-justify yung sagot ko dito. Kailangan ko magmadali. Anong sagot? No, the remedies available were not proper. Okay, as ruled by the Supreme Court, where the respondent is not exorbitant penalty imposed is not merely public censure or reprimand or suspension of 1 month's salary, the ombudsman's decision is appealable. And the proper remedy is to file an appeal under Rule 43 of the Rules of Court before the Court of Appeals. Okay. So, tandaan ko, kapag mga administrative agencies, in the exercise of their administrative something, then, ang proper mode of appeal is under 43. With respect to criminal charges, the remedy for the aggrieved party from resolution of ombudsman from probable cause is Rule 65. Okay. Here, the decision finding Miggy and Laida administratively liable with dismissal from service should they appeal via Rule 43 with the CA? Okay. The finding of probable cause and the other shall be questioned via Rule 65 petition with the Supreme Court. Okay. Bakit nga Rule 65? Rule 65. Ano ba meron dito? Okay. Basta, katandaan ko na lang yan. Kailangan ko magmadali. 3 minutes 33 seconds. Okay, let's go. Moving on. A search warrant was issued authorizing the police to search. Teka lang. Okay. And seize documents that will show that the respondent is guilty of swindling or estafa, copies of bounce checks, and all the... Is the search warrant valid? A search warrant, in order to be valid, must indicate the items, the place to be searched and the items to be seized. Yun ang requirement. So, meron kang items to be searched, documents, copies, o walang place kung saan ka mag-search warrant. It is invalid, guys. Confidently with the heart, ba yan? Sige. My answer, no. The search warrant is not valid. Under the rules, parang keyboard warriors dito, a search warrant must indicate the place to be searched and the items to be seized. Here, the enumeration does not indicate the place to be searched. Thus, hence, the search warrant is void for not indicating the place. Okay. Okay. Place to be searched or the person or thing to be seized. O, basta tama na yan. Sana 5 points na yan, no? Kahit ganyan kasimple yung sagot ko. Yan naman yung concept. Kailangan ko pahabain. Pero, yun nga. Ganyan ako sumagot. Kailangan ko ng mentor na magsasabi sa akin na, Kurt, bakit ganyan yung sumagot? Or papasa na ba yun? Meron ba pwede mag-confirm sa akin? Ganito lang ako sumagot. Sobrang, 4 sentences. Tapos na. Anyway, ilang minutes yun? 2 minutes 25 seconds, guys. 2 minutes 25 seconds. Pabilisan lang mag-type to eh. Tama naman. Nakuha ko naman yung sagot, diba? Anyway, let's move on. Last day of a losing party to file a notice of appeal from the Regional Trial Court to the Court of Appeals fell on June 12, legal holiday. Day after June 13, the counsel for the losing party moved that the period within which to file a notice of appeal be extended for 10 days, citing that the counsel's humongous caseload, among others, on June 23 the same year, without the motion for extension being acted upon, the counsel for the losing party filed a notice of appeal. Should this appeal be dismissed? Okay, anong issue ulit? Appeal. Okay, nasaan yung appeal? Eto. On June 23 that same year, without the motion for extension being acted upon, the counsel for the losing party filed a notice of appeal. Okay, hindi ko na-gets. Isa pa. The last day of losing party to file a notice of appeal fell on June 12. Okay? June 13, the counsel for the losing party moved that the period within which to file a notice of appeal be extended for 10 days. Okay. Citing the counsel's humongous caseload. On June 23, that same year, 10 days after June 13, without the motion for extension being acted upon, the counsel for the losing party filed a notice of appeal. Should this appeal be dismissed? Yes. Because there was no approval of such motion. No? So, ang question is does fresh period rule apply? It won't apply. No. Yes. The appeal shall be dismissed. Under the rules, the fresh period rule to apply, the fresh period rule applies only upon the order of the court denying a motion for extension. Here, there was no denial or action upon the court. Hence, in the case that there is no action by the court, the legislative period to file a notice of appeal shall not be told. Here, there was no denial action upon the court. Hence, the original reglementary period is maintained, and the losing party should have instead filed notice of appeal on June 13. Natin. A motion for extension of time to file is a prohibited. Prohibited motion na pala yung motion for extension. Okay. Prohibited na pala yung motion for extension. Ano 1 point for the effort? Kahit 1 point lang. Pero okay, prohibited motion. Tandaan mo, Carl, meron tayong prohibited motions na ngayon sa revised rules on criminal procedure. Hindi na pwede yung mga ganyang sagutan. Next. 4 minutes, 27 seconds to process that. Okay, the spokesperson of a special unit of the Armed Forces of the Philippines announced in a television interview that the Armed Forces was putting. Okay, teka lang. Let me remove this SD cards. Okay. Charge lang ako ng laptop. Okay. Sige. Tuloy. The spokesperson, okay, was putting all progressive and left-leaning party list representative under surveillance for alleged links to the ongoing surgery. Announced and progressive party list representative will receive for advice on how to discover the information that the armed forces may have collected through the surveillance options. Will a petition for the rate of habeas data be the proper remedy? Explain briefly. Petition for rate of habeas data, there's a balance, between right to privacy and threat to life, liberty, and property versus right to privacy. Yun ang pinag-usapan sa habeas data. Here, is there a threat? Okay, party list representative. So there is a threat. Yes, there is a threat to life, liberty, and property on the part of this outspoken progressive party list. So will the petition for writ of habeas data be the proper remedy? Hindi ko alam. Pinabigyan mo akong sagot. Balikin kita. Pero parang bangga naman. Whose right to privacy in life, liberty, or security. Life, liberty, and security pala, hindi property, guys. Life, liberty, or security, okay, is violated or threatened by an unlawful act or omission of public official or private individual engaged in gathering, collecting, or okay. Here, the party may properly file for right of habeas data as a right of privacy. Okay, right to privacy of those who may be under surveillance by the AFE is under threat. Okay, medyo siguro magkaka 1.2 points tayo doon kasi mag-yes din ako supposedly doon. Pero for the purposes of being more efficient, makamove forward tayo sa case na to. Mas magandang, tignan mo natin yung sagot. 2 minutes, 40 seconds. O, di ba? Okay. Now, Next question. Ang haba. Copy-paste natin. Okay. Ito yung mga tanong na ayoko eh. Mga writ. Parang kulang na kulang yung aral ko dyan. Mga writ na yan. Upon arriving. Upon learning of her husband that the wife and their daughter went up. Teka, question. Will petition or writ of amparo. Okay, sige. Upon learning of her husband's death, the wife and their daughter went to a funeral parlor where the husband remains dead. The husband be killed in military quarter in the hinterlands. He had been suspected as one of the members of an insurgent group which had been yearning for the violent overthrow of the status quo for more than 50 years. Upon arriving at the funeral parlor, the wife and the daughter found that the premises were guarded by heavily armed individuals clad in military uniform. These individuals accosted the wife and the daughter when they attempted to approach the husband's casket. The two were then interrogated for almost an hour, fearing for their lives. The wife and daughter hurriedly left after the interrogation. Okay? So, yung feeling for their lives. Okay, on their way home, they noticed a red car following them. Same car which carried individuals sporting crew cuts parked in front of their home for several days. The daughter noted the car's license plate and called the local police for assistance. The local police simply laughed at her, saying that they should just cooperate with the military, reveal all that they knew, or they would also suffer the same fate as her father. Now, will a petition for a writ of amparo prosper for the wife and the daughter? Okay, in the writ of amparo, ano nga ba ang sinolusyon ng writ of amparo versus sa writ of habeas corpus? Ano to, diba? Detention, tama ba? Illegal detention, writ of amparo. Are they detained? The question is, are they detained inside? They're not. Nandun lang sa labas yung mga polis. Ano dapat na file? Hindi ko rin alam. Sige, tingnan natin ang sagot. Of a suspected insurgent will prosper. Okay? In a similar case, okay, the totality of obtaining circumstances shows that the petitioner and her children were subject of surveillance because of their relationship with the suspected member of the New People's Army, creating a real threat to their life, liberty, or security. So, corroborated by the who also witnessed a constant police drive-bys marked vehicle. Ano ba yung rate of amparo? Hindi ko na alam, guys. Pero nagmamadali ako. Balikan kita. Paano ko ma-take note na hindi ko alam yung rate of amparo? Dapat meron akong listahan ng mga hindi ko alam na babalikan ko eh. Saan ba? Saan ba ako pwede maglagay? Sige, dito tayo sa bar tracker. Let's go. Rate of amparo. Okay, ito. Please study. Very good. Okay. Sige, game. So now. Natin ito dito. Ano siya doon? Okay. Case of similar facts. Tapos here. Okay. Next. Moving on. Bilis. 4 minutes, 8 seconds. Naka 16 na tayo out of 556. Pwede ba gumagalaw tayo, guys? In an information, a man was charged with having forcible carnal knowledge of a 16-year-old woman. The information did not contain any allegation concerning the victim's relationship with the accused. During the direct examination of the accused, the prosecutor was able to elicit information that the accused was the 16-year-old woman's father. Okay. So, the defense counsel failed to object to the testimony, having also been surprised by the revelation. After trial, the judge convicted the accused of simple rape and imposed a corresponding penalty. Okay? The prosecution moved further, considering that the accused could be filed of qualified rape and a simple rape because the was proven, even as it has been alleged in the operation. No, no. The prosecution is not correct. Under the rules, qualifying circumstances must be alleged in the information. Uh, Also, in cases decided by the Supreme Court, um, the subsequent proving of qualifying circumstances where there was no mention of such in the body of the information were not appreciated in determining the the penalty, the offense to be meted against the accused. Further, um, also well settled that the failure to include in the information and acceptance of such circumstance upon proving in trial would result to the violation of the right of the accused to be informed of the uh, offense charge against him. Here, the qualifying circumstance of ano to? Relationship of paternal relationship was not included in the information, hence it cannot be appreciated by the court, and prosecution's contention is untenable. Anong sagot? Hindi ko na-mention tong aggravating na lang siya dapat. Mali ako dun. Yung determining the penalty, hindi mo siya na-appreciate. So, dapat mga 3 points man lang. Please po. Sos ko. 3 points lang. Mali yung mga rationale mo, Carl. Hindi, tama naman. Pero yung penalty, considered pa rin siya. Appreciated siya as an aggravating circumstance. Hindi na siya qualifying, pero aggravating pa din. Ha? Not pleaded but proved. Pwede siyang maging aggravating circumstance. Okay. So, aggravating circumstances, if not pleaded, will not be appreciated, di ba? Pero qualifying circumstances, when not pleaded and later proved, can be appreciated as aggravating circumstance for purposes of determining penalty. Okay. Tandaan mo yun, Carl. 4 minutes, 58 seconds. Let's go. Will a petition for mandamus lie. Teka, naglalag yung laptop ko. Bakit? Ano bang ginagawang processes ng laptop ko? Okay. 1 hour na lang. Naka 1 hour na tayo, guys. Another 1 hour. And lalaki na tong puno ko. Gusto nyo ba makita yung puno ko? Yan siya. Yung puno. Ginagamit kong app is Forest at saka yung Yolpomta. So, gusto nyo akong samahan sa pagtatrack ng study times ko, go to Yolpomta, search for, ano bang group to? Attorney 2025 QT in Yolpomta. Sabay-sabay tayo mag-aral. Makita nyo yung study times natin. Yan, guys. Sige. Ay. Okay. Let's go. Itsura. Sana. Well, a petition for Namandamos Light to compel the Secretary of War to convene representatives of neighboring countries similarly situated with the Philippines or for them to find diplomatic... no. 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 The petition for Mandamos will not lie. Under the rules, hindi pala rules. Under international law. And as decided by the Supreme Court, may case nga pala to. Mandamus shall not lie for in relation to political issues as the same as that power is vested solely to the President of the Philippines. Here, the petition to compel the Secretary Foreign Affairs. Hindi pala. Here, the petition for Mandamus is filed for the purpose of requiring a convention between neighboring countries. Additionally, Mandamus may only be issued when there is a clear right on the part of the one filing Mandamus, and that there is an obligation on the part of the other party to do the same. Here is filed for the purpose of requiring a convention between neighboring countries. There is no obligation on the part of the Secretary of Foreign Affairs to convene. With neighboring countries. Hence, the Mandamus will not lie. Why so clear as believe no for the extension is that which page. Ewan ko kung tatama yun, pero tama naman yung no. So, nabigyan akong 3 points. Kung mga ganito yung sagutan ko, no? Sana. Yeah, sasabi. Sige. Sige, next. Next. That was 5 minutes 12 seconds. Ang tagal ko naman nag-analyze. Can dolphins be plaintiffs in a suit to enjoin a land reclamation that will affect a biodiverse coral reef? Putek. The question. Pwede ba? Doctrine of transcendental importance. Ano ba to? Ano to? Yung sa environmental protection, yung sa, Subic Bay? Ano to? Writ of kalikasan, ang pinag-uusapan dito. Ang tanong, pwede ba mag-file ng writ of kalikasan? Itong mga dolphin. Sino ba pwede mag-file? O dapat may local standing. May legal standing ka. There is an actual case or controversy. You are a real party in interest. You are supposed to suffer. Yes, you are suffering. Ano pa ba? Apat yun eh. Local standing. Sagutin ko to. Pwede ba? Eh, ang tanong kasi may legal capacity ba sila to file in the first place? O sino ba ang pwedeng maging party? Anyone who is not incompetent to be a party. Potek, hindi ko alam. Kunin na natin yung sagot. Masyado matagal. They are not natural or juridical persons. O yun. O dapat natural or juridical person. Oo nga naman. Resident marine mammals versus race. Ano ba naman yung nag-file lang kasi yung mga mammals? That the need to give the resident marine mammals legal standing has been eliminated by our rules, which allow any Filipinos as a steward of nature to bring a suit. Hindi sila pwedeng gawing plaintiffs, pero pwede yung Filipino citizen to actually be a steward of nature, to actually file in behalf of the nature itself. So that is the doctrine in marine mammals legal standing. Okay, sige. Teka, Ali, nag-aaral ako. May batok. Si batok. Okay. Sige. Matandaan mo ha. Hindi sila natural or juridical person. And as ruled by the Supreme Court, any Filipino citizen may file as a steward of nature to bring the suit to enforce our environmental laws. Remember that, Carl? That is 2 minutes, 50 seconds. Okay? Is the printout of a photograph from your mobile phone showing a fly in the soup you ordered admissible in evidence in action for damages against the restaurant owner? Yes, admissibility lang naman ng evidence. Yes, the photograph for is admissible in evidence. Under the rules on evidence, photographs that are still inside, ano ba to? Which are captured and stored using an electronic device are admissible in evidence as documentary evidence. Okay? Here, the photographs is from my phone. Banggitin natin yung sinabi kanina kapag documentary evidence. As part of electronic document evidence. Electronic as documentary electronic evidence. Okay. The photographs is from my phone. CCTV pala yung pinag-usapan kanina. O sige. Hence, same is admissible as evidence. Okay, yes. Print out of a photograph. Print out. Pares lang. Original to. O basta yes. Sana bigyan man lang 3 points dyan. Pero kailangan ko i-improve paano ako sumagot. Sige. Next. 2 minutes 39 seconds. Let's go. Inspired by the movie On the Job, the superintendent of the new Bilibid prison without any court order transferred 10 persons to private liberty on an agricultural farm in Duval del Norte to plant kamote. The owner of the agricultural land The owner of the farm promised to ensure that the persons in private delivery would not escape. Always wear the proper uniforms. 2 of these 10 persons in private delivery will found a way to approach you and suggested that you file a petition for the writ of habeas corpus on their behalf. The persons deprived of liberty added that they had no family in Davao and that their families had no means to visit them there. Is a petition for the writ of habeas corpus a proper remedy for the case? Explain briefly. Writ of habeas corpus is illegal detention. Ito ata yung illegal detention, hindi writ of amparo, no? Pwede kayo ba nga ulit ng habeas corpus sa amparo? Sige, discuss mo na sa akin. Gusto ko nang makamove on. Kailangan mabilis tayong kumilos. O hindi daw proper yung petition for writ of habeas corpus. Ganun kahinaan ko eh. Pang petition for. Inspired by the movie On the Job. Okay. Okay, the court in Reyes. The rate of habeas corpus may be available as post-conviction remedy when, as a consequence of judicial proceeding, end of the following is there has been a deprivation of a constitutional right resulting in the restraint of a person. The court had no jurisdiction to impose sentence. The imposed penalty has been excessive, thus avoiding the sentence as to such excess. Here, none of the exception. The fact that PDLs have no family in Davao is not a proper ground to file. Okay. Sige nga. Oh, pagawa natin na mnemonic. Mahuhulaan mo bang requisites to? Oo, alam niya. Exceptions to the rule on finality of judgment. Specifically when a writ of habeas corpus. Guys, ang galing sa ChatGPT, guys. Okay, mnemonic. Constitutional rights justify excess rescue. Okay. Bakit ganun? Can you find another mnemonic? Mas pwedeng mnemonic. No jeep. No judgment ends everything permanently. Oh. No jurisdiction lacking. Okay? No jurisdiction. There's excessive penalty. There's an essential constitutional right denial. And the person is illegally restrained as a result. Ano ba mas gusto kong matandaan? 1. There's been deprivation of a constitutional right resulting to the restraint of a person. The court has had no jurisdiction to impose a sentence. Okay. Justify. The imposed penalty has been excessive, thus voiding as to such extent. Okay. Paano ko tatandaan ito? Writ of habeas corpus. Jurisdiction lacking, excessive penalty. Essential constitutional right is denied. Person is legally restrained as a result. Tatlo lang eh. Pero jeep is good. Can you try another one? Parang okay na yung jeep. Okay, sige. Cap, rule breakers. Constitutional right deprived. Absence of jurisdiction. And penalty excessive. Oh, mas gusto ko to, cap. Gusto ko to, cap. If they break the cap, you can break free, even after judgment. Think of cap as the basic protection over your rights. If it's broken, habeas corpus can step in. Ang galing! Ang galing. Gusto ko to. Can you see? Provide the visual. Pwede ba yan? Rule breakers. Sige, okay na yun. Tandaan mo to, Carl. If there's cap. Okay. No, mnemonic a cap. Cap rule breakers. The cap rule. Tandaan natin, guys, the cap rule. There is constitutional, ano to? There's a constitutional right deprived. The authority of the court. There's an absence of jurisdiction. The court has authority to impose sentence, and the penalty is excessive. So void as to the excess. Cap rule breakers, let's go! Okay, sige. Next. Next. Okay, gano'n katagal yun? 6 minutes, 11 seconds. Okay. On her deathbed. Copy na lang. Copy. Never again na sinigaw. Mga kababayan, never again. On her deathbed, your grandmother revealed to you that in 1994, she and her family won a civil action for damages against a former president for human rights atrocities committed against them during the martial law. Oo naman ha. Kita mo ha. The judgment was never appealed. Your grandmother informed that she never had the judgment executed because she wanted this to be her parting gift for you when she passed. Okay. Now, she said that she also felt the need to wait for one of her grandchildren to become a lawyer. It so happened. Okay. Okay. It so happened that you have just passed the best bar ever 2021. Okay. Your grandmother spent her last moments narrating how she had been arrested by the military during martial law and was then tortured and raped while under detention. She emphasized that her case was not unique and that until now, she was yet to receive an apology from any member of the former president's family. With her last breath, she instructed you not to let her experience happen again. Her parting words to you were, "Never again." Is an action for revival of judgment, the proper remedy to enable the judgment's execution. Explain briefly. Revival of judgment. 1994. Pumasa ka nung best bar ever. 2021 na yan. Okay. Na-release yun nung, I think December, mga March tayo ng 2022. Okay. Nagpas na tayo sa reglementary period. Can you still? 1994, 2004 yung 10 years ng prescription. Okay. So, nag-prescribe na yung right. So, ano proper remedy? She never had the judgment executed because she wanted this to be her parting gift for you when she passed. She never intended to have the judgment executed in the first place. To enable the judgment's execution. An action for the revival of judgment. The proper remedy to enable the judgment's execution. Explain briefly. No. The judgment's... Ano? No. The action for revival of judgment is not the proper remedy. If not, then what? Prescribed na eh. Hindi ko alam. Sige na. Ano sabi? Wala, prescribed na eh. 5 years, diba? Exorted 5 years. After last, before it's barred by statute of limitation. Statute of limitations is 10 years. So, ibig sabihin, yung order, pwede kang motion for execution of judgment within 5 years. Tapos after noon, within 10 years, naglalapse yun yung statute of the, maybe enforced by, I don't know, after the lapse of such time to file. So after 5 years, 10 years naman, okay? Independent civil action, okay? Kasi claim under the judgment process after lapse of 10 years. Ay, 10 years, ito. Here had long been final securities. Ang tanong, ano ba yung proper remedy? Anong proper remedy? Hindi mo ako binigyan ng remedy. Sana sinagot ko na nga talaga to. I would have gotten 5 points. Char. Hindi natin alam kung tama yung sinagot ko. Dati sinagot ko na, no? Eh, kasi feeling ko manghuhula ako talaga ng malala eh. Pero at least tama naman yung concept. So, bigyan mo ako kahit 2 points man lang or 3 points justice for answering no. At least medyo tama naman. So, decision. Next, bilis. 435. Remedial. 2021. Okay. Mga actual bar cases to, no? A party through counsel filed a complaint to nullify. Teka. Nasasanay na tayo, guys. Sobrang nasasanay na tayo magsagot nitong mga to. Bumibilis na rin yung ano natin, pagsasagot natin. We're training the muscle to answer the cases quickly. A party through counsel filed a complaint to nullify the extrajudicial foreclosure of mortgage done by a creditor bank. The bank had already filed its answer. However, the counsel for the plaintiff felt that the judge was partial to the defendant's counsel. Wanting to bolster the chances of winning for their client, the counsel for the plaintiff filed a second case against the same bank seeking to nullify the same extrajudicial, but this time adding a prayer for the award of damages. The second case was raffled on the judge. The defendant bank's counsel then moved to dismiss the second case. Okay. No. Meron tayong forum shopping. No. Hindi pala. Motion to dismiss on the second case. Yes. The motion shall prosper. The motion to dismiss the case shall prosper. Teka, ano ba to? Baka madali naman ako ng prohibited pleadings ito Motion to dismiss is bawal na dapat final siya as an affirmative defense. Dapat ang pagkaka-phrase dito, the defendant's bank counsel on its raised the affirmative defense that move to dismiss. Ano ba naman to ba? Prohibited na nga, diba? Motion to dismiss except sa res judicata, prescription, ano pa? Res judicata, prescription. Kasi meron akong mnemonics din nun. 4 yun. Lack of jurisdiction over the case, over the subject of the case, and kasama yung laging res judicata and litis pendentia. O litis pendentia to. So pasok siya sa motion to dismiss. Sige. Shall prosper under the rules. Vice rules. The motion to dismiss is proper when the basis is litis pendentia. Here, there is a first case. Litis pendentia is present as there is another case filed for virtually all same parties for the same subject between the same parties and for the same subject matter. Hence, motion to dismiss shall prosper. Okay. Ano sagot? Litis pendentia. Okay. Jury. Okay. Okay. Same cause of action, same prayer. The previous case not having been resolved yet were the ground for dismissal is litis pendentia. Identity of the parties. Identity of rights as certain relief prayed for. Same facts and identity of the cases. So, judgment in one regards. Okay, bigyan mo ko ng mnemonic. Come on. Alam mo bang litis pendensya to? O rejudicata of prior judgment? Hindi naman. This is for litis pendensya. Okay ha. Thank you for clarifying. You're referring to the requisites for litis pendensya, not res judicata. When two are related, it's for dependency of another action involving the same matters. Let me now give you a fresh na mnemonic. Okay. PRA identity. PRA identity. Parties relief action. Parties are the same. Relief is the same. Action leads to same outcome. Pwede, para mo nang tapusin yan, isa lang naman ang kaso. Tag-respawn. Para mo na yan tapusin. Para mo nang tapusin yan, isa lang naman ang kaso. Para mo nang tapusin yan, isa lang naman ang kaso. Can you try another one? I like the pun intended. Can you try another one? Okay. Parang pareho. Yan. Parang pareho. It's like the same case. Used to justify dismissal due to... You deserve a clap. You deserve a clap. Oh. Just... I need a review card. To a call and response format. Ayoko nang... Okay, cancel. Stop it. Una yung process. Sige na. Wala ka na. Paano pag kinapit yung silid ko? Anong itsura niya? Yeah. Stop it. Stop it. Pareho ang parties, relief at parties para ang parties are the same, relief is the same, and case pareho rin ng effect. Ang case pareho rin ng effect. Ito kasi, para mo nang tapusin yan. Mas okay yung pero pareho. Can you do pero pareho? No. Do text only and not table. May ibang kaso pero pareho lang. Parties, relief outcome. Ayan. Same parties, same relief, same outcome. Yan ang dapat mong tandaan. Very good. Pero pareho. Okay. Copy paste. Pero pareho, tandaan mo yan, Carla. Pero pareho. Matandaan mo ito. Pag binalikan natin ito, makalimutan mo. Jurisprudence. Huwag mo kakalimutan to. Well, likely makakalimutan ko to. Pero babalikan natin to. Okay, next, bilis. Ano to? 8 minutes, 39 seconds. Ang tagal ko namang ina-analyze yun. Hindi pwedeng ganun kabagal. 2 years after receiving a copy of the decision rendered by regional trial court, the party engaged a counsel and asked them to work on reopening the case. The party explained that it took 2 years to find the best legal counsel possible and that counsel had to wait 2 years to pass. Kakapasa lang. After perusing the judgment, the case records. The counsel, kasi nga nagka-pandemic, ang hirap nga naman maganap ng counsel. After perusing the judgment, the case records. The counsel filed before the Court of Appeals a petition for annulment of judgment under Rule 47 of the Rules of Civil Procedure, asserting the trial judge improperly assessed the evidence and misapplied the doctrine long adopted by the Supreme Court. Annulment of judgment prosper. Ang basis for annulment of judgment shall be based only on fame, fraud, accident, mistake, and excusable negligence. If that is not the case then, kasi same lang yan, di ba? It's either a motion for new trial kapag hindi pa tapos yung judgment, pero pag nag-final execution na, motion for, ano to? Hindi pala. Petition of annulment of judgment. Yan. Okay. Parang new trial, tas may judgment, tas petition for annulment of judgment. No, the petition shall not prosper. Under the rules, the petition for annulment of judgment shall be based in either fraud, mistake, accident, and negligible negligence. Excusable negligence. Okay. Here, the basis of the petition is that there was improper assessment by the judge and misapplication of a doctrine. Hence, the basis not being one of the four things mentioned above, the petition shall be dismissed. It's only proper if it's based on extrinsic fraud and lack of jurisdiction. Mali. Pwede pong 1 point. Tama naman na it will not prosper. And misapplication of doctrine are not proper to support the petition for annulment of judgment. The petition should therefore be dismissed. Wait. Sana kahit 2 points bigyan ako ng ganito, no? Mali yung basis. Pero sabi naman ni Justice Ener, pag nag-check sila, usually ang daming chine-checkan. Pag tumama naman yung first, okay na, check na. Sana ganun laging magmadali sila. Sana marami tayong mag-take para sila magmadaling mag-check. Para kapag tumama yung yes or no natin, 5 points! Okay. Pero pag daw naman mali yung yes or no, saka sila titingin dun sa justification mo. Baka naman kasi tama, may pinuprove ka. No? So, sana pag yes or no, tama na kagad. Marami akong hula na tumatama. Parang 50-50 kagad, di ba? Sipin mo yun. 50-50. It's either 100%, 5 points ka, or maka 1 or 2 points ka for the consideration na nagsagot ka. O, okay na din. Sige. O, lap. 3 minutes, 58 seconds. Okay, provisional remedies and special civil actions. A, B, C. O, bilisan. Bilis. Bilis. ABC Homeowners Association Incorporated sues Mr. X before the RTC for collection of unpaid dues. Mr. X filed a motion to dismiss solely on the ground of lack jurisdiction asserting that the house. Ito yung case that has jurisdiction under. Okay. Hindi pala ito yung nag-file siya ng HLURB tapos pinasa niya sa RTC. Tama ba? RTC, sabi niya walang jurisdiction. Kasi HLURB. Tapos, nung dinanay ni RTC, sabi niya may jurisdiction ako sa case. Tapos nag-file ngayon si Mr. X ng petition for certiorari under Rule 65 na may grave abuse of discretion on the part of RTC in denying his motion to dismiss. Question. Is Mr. X choosing a remedy of certiorari and direct recourse to Supreme Court proper? Okay. So, sa RTC siya nagpunta, sa ABC, sabi ni X, hindi, kay HLURB ako. Ang question dito, Homeowners Association. So, HLURB talaga to. Pag sinabing walang jurisdiction, mali. Mali ang remedy. Mr. X remedy was not proper. Under the rules, when jurisdiction is deemed... Teka. Sabi pala ng RTC, hindi, meron akong jurisdiction dito. Tama pala. Tama pala. Was proper. So, hindi ito yung case nung binago nila yung set of facts. Ito yung nag-forum shopping eh. Mr. X remedy was proper. Under the rules, Rule 65 is a proper remedy for cases involving grave abuse of discretion amounting to lack or excess of jurisdiction. Here, Mr. X is questioning the jurisdiction of the court itself. There being no other plain, speedy, and adequate remedy, Rule 65, the remedy of Rule 65 afforded by Mr. X is proper. Letter B. Assuming the material of motion is granted by the RTC to challenge the RCC ruling. Bakit mo i-challenge yung RTC ruling? Hindi mo pwedeng i-file na lang sa HLURB. Okay, sige. Dahil gusto mong i-challenge yung RTC. So, si ABC. So, sabi niya, okay din na. Okay. Sige, tama ka. Wala kang jurisdiction. Ba't mo ba i-challenge yung RTC? File mo na lang ulit sa HLURB. Kasi pagdating doon, barred na by estoppel to si Mr. X. Case 2 eh. Pero bakit ganitong tanong? Ano ba? Proper remedy. The proper remedy is to file the case with HLURB. Under the rules, if the case is dismissed without prejudice, the proper due to lack of jurisdiction, the proper remedy is to refile the case with the proper court. Hence, the best remedy in this case is for ABC to refile the case with the HLURB. Sana tama. Pero kasi mas madali ito kung meron ang tanong is there can Mr. X deny that the HLURB has jurisdiction? No, you're barred by estoppel. Proper o mali? All the should be resorted when there is no show against project. Montes Court of Appeals. Doctrine of hierarchy of courts and certiorari petitions, although Supreme Court has concurred the jurisdiction in certiorari cases. Pwede rin niya ba itong i-file? Okay, sige, mali ako. Case yun. Assuming that Mr. X motion to dismiss on the ground of lack jurisdiction is to file a notice of appeal. File a notice of appeal. Okay. Dapat pala nag-notice of appeal. O sige, noted. Noted po. Sige. Sino yung B? Okay, noted, noted. Next. 7 minutes. Okay, next. Sino ang question? Ito. Ano ba to? Ayoko ng mga nanganganak-anak. Ang dami namang anak ng tanong na to. 9%. Grabe ka naman, boy. Ba't ka nagpa 9% question dito? Sige, wala tayong choice. Ito yung bar question. Sagutin natin. Continue thereafter. Miss A filed a complaint for damages against Miss B, alleging that Miss B negligently caused the demolition of her house, concrete fence, top half of which fell on the front portion of Miss A's car, and permanently damaged its engine. In her answer, Miss B denied any personal for the damage caused to Miss A's car, averring that she merely acquiesced to the advice of her contractor, XYZ Construction Corporation, to have the concrete fence demolished. Okay. Thus, the damages, if any, should be collected from the construction company. Thereafter, Miss A filed a motion for judgment of the pleadings, alleging that Miss B's statement in her answer is actually a negative pregnant. Miss B opposed the motion, reiterating her defense in her answer, which purportedly rendered judgment of the pleadings improper. Teka. Si Miss A, siya yung nag-file ng complaint. So, nag-file siya ng motion for judgment on the pleadings. Kasi yung statement ni B is actually a negative pregnant. So, dinideny niya pero actually admitting the same. So, Miss B opposed the motion, reiterating her defense in her answer, which purportedly rendered judgment on the pleadings improper. Mali yung motion of judgment of the pleadings, Miss A. Miss B also moved for the dismissal of the case on the ground of non-joinder of XYZ Construction Corporation, which she alleged is okay, kaya pala nanganganak yung tanong. Ang daming tanong. A. Question. Is May's motion for judgment on the pleadings proper? Explain. 3%. Judgment of the pleadings. Judgment. Pag judgment of the pleadings, ito is sham. There's no actual issue. Tama ba? Naalala ko si attorney. Si Vice Dean Senga. Sham. It's a sham. Judgment of the pleadings, it's a sham. Okay. Sige, naalala natin, attorney. Vice Dean, thank you so much for the sham. Tama ba? Judgment of the pleadings ba yun? Okay, sige, tingnan natin kung naalala natin na tama. Is Miss A's motion for judgment of the pleadings proper? So, sinasabi niya, sham yung sagot Miss B. Hindi eh. Hindi naman sham. No. The motion is not proper. Motion on the pleadings under the rules is proper only when there is no actual issue, and that in the case nag-negative pregnant, inadmit niya na may damage kay A's car, pero parang tama pala, no? Wala namang issue, inadmit niya. Yes, the motion of Miss A is proper. Motion under the rules, motion for judgment on the pleadings is proper when there is no actual case or controversy, no actual dispute as to the facts of the case. Here, the negative pregnant answer of Miss B admitting damages to Miss A's car, although imputing the damages should be um, claimed against XYZ construction ko. Effectively removes the dispute as to damages caused. Hence, motion for judgment of the pleadings proper. Okay. Letter B. XYZ construction and indispensable. Sabi ko na magiging tanong to eh. Is dispensable or necessary party. Okay. Ang indispensable party is someone for which the case cannot be fully there is no full, the prayer cannot be fully implemented if the indispensable party is not implemented. Here, it's not. Ano siya? Necessary party ba siya? Hindi siya indispensable, definitely. Necessary party ba siya? Pinagkaiba ng indispensable sa necessary. Sige nga, distinguish mo, Carl. Indispensable, kapag hindi mo siya na-implead, void yung judgment because you cannot have full recovery of everything. Necessary party, impleaded. Necessary is mga counterclaim, cross-claim, whatsoever. XYZ is a necessary party. Under the rules, a necessary party is that which is not indispensable in the case, but must be impleaded if full to satisfy full claims have to be satisfied. Something like that. Hindi ko alam paano siya i-put into words dahil familiar lang ako sa sagot. Here, XYZ is not an indispensable party as the case may be decided upon only with Miss A and Miss B. So siya ay permissive counterclaim, cross-claim, permissive cross-claim. Ay, nako. C. Assuming that XYZ construction co is an indispensable party, it's non-joined. Hindi naman, so mali ako dito, indispensable to. Okay, sige. Laging ganito eh. Assuming, syempre. Indispensable ba siya? Sige na nga. Panindigan ko yung necessary. Assuming indispensable, is its non-joinder a ground for the dismissal of the case? Yes. The non-joinder of an hindi pala. Party. No. Is not a valid ground for the dismissal of the case. The proper remedy is for the court to order the joinder of such indispensable party. However, if upon order there is still a refusal upon the parties to include such indispensable party, the case shall be di-dismiss ko ba pag wala yung indispensable party? Sige, kunyari ganyan. O, anong sagot? Anong sagot? Yes. Tama, under the rules of civil procedure or judgment. O, di ba? Nag-admit. Okay, sige, tama yung sagot natin sa A. 3 points yan. 3% yan. O, tama yung necessary party natin, guys. This one would be directly affected or necessarily produced by the judgment that would be rendered in the case. Okay? China Bank, blah, blah, blah. Here, XYZ would not be directly affected or necessarily produced by the judgment. XYZ is a necessary party. Under the rules of civil answer is the one who should be joined for a complete determination or settlement. Yun, that's the term. A necessary party is one who should be joined for complete determination or settlement of the claim subject of the action. Here, XYCCC, Construction Corporation should be joined for a complete determination or settlement of the claim. For a complete determination of settlement. Yung akin, ano sabi ko? If full claims have to be satisfied. Medyo malapit, pero a complete determination or settlement of the claim. Determination or settlement of the claim. Tandaan mo yan, Carl. Tandaan mo yan, Carl. No. The non-joinder of the so, tapos ang sagot. O, yan. The non-joinder is not a ground for dismissal. The SC has held the non-joinder is a ground for dismissal of the case. 9 points to, guys. 9 points. Sana 9 points talaga, no? Sana mabait sila mag-check talaga, no? Pero sige. 9 points yun. Ang haba nung sagot. Pero kung na-encounter ko to sa bar exams, so ganito ba ako kabilis magsagot? Well, laking tulong kasi na nag-aral ako ngayon. Kasi before, hindi ako nag-aaral. Lahat hinulaan ko sa bar exam, 74.2. Sus ko po. Nagagawa ko sa buhay. Nasaan na yung letter C? Ito. Okay, next. Gano'ng katagal ako nagsagot? 12 minutes for 9 points. Worth it ba yun? Oo. Parang 6 minutes for 6 points. For 4.5 points. Pwede na yun. Pwede na yun. Oh, yung tanong dito. Hindi ko alam kung papasa ba ako pag in-scorean ko lahat ng tanong at sagot ko dito. Pwede nating scorean mamaya. So, dapat nagsagot na rin ako dun sa mga no? Mga hinuhulaan ko. Hindi, assume natin na 0 yun kasi wala akong alam. Papasa ba ako? Kahit 0 ako doon. Sige. Bigyan natin ng 2 points yun. Kasi mag-e-effort naman ako doon kahit paano. Or kahit 1 point for the effort, bigyan natin 1 point doon. Mga wala akong sagot. Okay. Mr. C sued D for conveyance of property and damages, claiming that Mr. D, through fraud and forgery, was able to obtain the lot which was previously registered in Mr. C's name. The complaint was filed before the RTC. Mr. D moved to dismiss the complaint on the ground of lack of cause of action. In opposition, Mr. C argued that lack of cause of action is not the ground for a motion to dismiss as the ground provided for Rule 16 of the Rules of Courts. Failure to state a cause of action. Ulit itong binanggit sa atin ni Justice Henner. Okay? Distinguish the concepts of lack of cause of action and failure to state a cause of action. Based on the distinction, is Mr. C's opposition tenable? Okay, let's discuss first. Lack of cause of action pertains to the actual to the state of lack of the presence of the requisites for a valid cause of action, which is ROVID. Sabi ni Justice, that there must be a right afforded by the law to the plaintiff, an obligation to respect such right by the defendant, a violation of such right and the corresponding damages due to such violation. On the other hand, failure to state a cause of action simply means that even though the requisites mentioned above are exists in the case of and there was a failure to state the same in the complaint filed by the plaintiff. Okay. Mr. C's opposition. Ano ba ang sabi ni Mr. C? Mr. C argued that lack of cause of action is not the ground for motion to dismiss, as the ground provided is failure to state a cause of action. Hindi naman. Is untenable. Motion to dismiss is only proper when when the complaint is bereft of cause of action. Failure to cause of action is not a motion to dismiss is not the proper remedy for the failure to state a cause of action, and the same may be determined by the court during trial. Okay, sagot. So, failure of to state a cause of action, validate of failure proof as a ground of motion to dismiss. Failure to state a cause of action is a ground of motion to dismiss, while lack of cause of action. Mali ako. Zero. Tama pala. Demurrer to evidence pag walang cause of action. Oo nga naman. Ano ba yun? Pero failure to state is a ground of motion to dismiss. Ano ba yun? Dismissal of the complaint on the ground of failure to state a cause of action would not bar the refiling of the complaint because this is a dismissal without prejudice. Okay. Okay, natapos na natin yung 2 hours. Grabe, ang bilis. Ang bilis talaga. Sobrang bilis. So, magpapahinga na tayo. Tapos ko lang to. Copy-paste ko lang to. Okay. As to nature. As to ground. As to preclusive effect. Okay. Tapos, gano'n katagal ko sinagutan yon? 6 minutes. So, 3 hours na tayong live ngayon, guys. 3 hours. You're now live for grabe, 3 hours na ako nag-live ngayon. Grabe naman. 3 hours na akong live. Whew. Live. Pahinga muna, pahinga. Ang dami ko ng mga puno sa forest. So, kumusta naman yung progress natin, no? Gano'ng kabilis? So, 73, 71 out of 556. 71 out of 556. 12%. I have 10 days to accomplish all these. 10 days. Oh, so nakatapos na ako ng 10%. Ano ba dapat ang matapos ko in one day? Approximately, that makatapos ako ng mga 60 to 70 questions in a day. Pwede na yun. Quota na ako, guys. Quota na ako, guys. Maraming salamat for watching this live. Quota na ako for today's video. Bukas ulit. O, diba? Hindi natin nararamdaman masyado na sobrang tindi natin mag-aaral. Kasi 3 hours lang nakaka-accomplish tayo. Okay, so, pero yung panonood ko ng Legal Edge, hindi ko na nila-live stream kasi tinititigan nyo lang ako. Diba, ang boring naman nun. Nagla-live stream ako, tinititigan nyo lang ako. Pero pwede naman. Live ko pa din. Try ko i-live kapag nanonood ako, pero mas gusto kong i-live kapag ganitong nagsasagot tayo para medyo interactive. Hindi ka naboboard kasi salita ko ng salita. Na-imagine ko na nandyan kayo lahat. Kahit wala naman tao. It keeps me accountable. It keeps me focused on what I have to do. I should not be scrolling around on Facebook because I know I'm being recorded. This is live, right? I know you're watching me. You're holding me accountable to actually review when it's time to review. So, yun, guys, if lang naman gusto niyo na accountability buddies and gusto niyo mag-aral together, kasabay ng live ko, just ping me, send me a message, maybe in the comments or yun. And we can find create a study group. Pero yun, dahil sa sobrang ingay ko mag-analyze like this, ano nangyayari, no? Possible bumagal kasi ako mag-review. Kapag nag-review tayo sabay, tapos magbabasa pa tayo whatsoever, ako nagmamadali ako, nakita nyo. Naka-time trial ako dito, so stop muna natin to. Yeah. 3 hours, 21 minutes. Naka-time trial tayo, lagi tayo aligaga at magmamadali. So, I'm not sure if my pacing is something that's something you would want. But if in case you want it and you just want to listen to the analysis, yeah, you're free to do that as well. So, this is the pacing that I'll be doing. If mga kayo, wala kayong time mag-aral, try nyo pakinggan yung analysis ko dito, no? Try nyo ding sagutan on your own. Pero better gawin nyo to siya on your own para may kayong, ma-practice nyo din yung typing skills nyo, mag-produce ng sagot and whatsoever. So, pero kung wala kayong magawa and wala kayong time mag-review, wala kayong so yung gusto nyo, hindi siya yung parang didiscuss ng prof, kundi talagang hinihimay isa-isa, nagkakamali din at tao din yung pinapanood nyo. You can watch my videos. It's available on YouTube and YouTube. It's available on YouTube and I also do live stream for my friends on Facebook. So yun guys, thank you so much for watching today's live video and see you on the next video. Bye.